Welcome to IDR Intel with me, Stephen Lawson. First, a little bit about me. I'm a specialist contentious probate lawyer, and as you can probably tell, I've been doing that for a long time. And much of my work is in common with private client practitioners. I'm the current chair of the Law Society Wills and Equity Committee, and I was previously the chair of STEP Cheshire, a member of the STEP England and Wales Committee, and a member of the STEP Worldwide Council. And in all of those contexts, as you can appreciate, most of my work and my contacts are with private client practitioners. It's always been my mission to give back to the profession the things that I've learned from my day-to-day contentious probate work. So I'm delighted that IDR are producing this IDR Intel podcast for you. It's about exactly that. It's about our intelligence. It's about the things that we see. It's about the issues that come to life for us before they're reported in the news or the legal profession. So we wanted to share that. And we've got about 20 lawyers here doing nothing but contentious probate work. It's all we do, and we want to share. And there's just one other thing I want to say about that. In our experience, there is absolutely no secret within the private client world as to who operates best or who operates worst. In other words, we've seen the best of legal practice from young, keen, enthusiastic will preparers, and we've seen some of the worst legal practice from some relatively senior lawyers, and that you might find surprising. We've seen some of the best legal practice from small firms and some of the worst legal practice from big firms. But the converse is also true. We've seen great practice from big firms and poor practice from small firms. So in other words, what we're saying, excellence can be found anywhere. We recognize that, and we want you to be able to celebrate that. You're giving up your time to listen to these podcasts, so we want to try and give back to you. So today, using the insight and the intelligence we've got, I'll be talking about the Law Commission, the non-contentious probate rules, and the recent case of Waldrop and Searson. We will have full notes on our website, so you don't need to write everything down. First, the Law Commission. The Law Commission is a statutory body created by Parliament in the Law Commission Act of 1965. Their objective is to keep the law of England and Wales under review and to recommend reform where it's needed. And the Law Commission first consulted on reforming the law of wills in 2017. And this was highly significant because it was the first major review or consideration of the law as to where we're at since the Wills Act of 1837. So the impact of this consultation was huge. And the Law Commission considered virtually every aspect of the law relating to wills. For example, the capacity required to make a will, the formalities of a will, how old you had to be to make a will, whether you needed one witness or two witnesses, whether you could revoke a will, how you could revoke a will. They looked at mutual wills that are binding on two or more people, and donatio mortis causa. So it was absolutely vast. It was over 200 pages, the consultation alone. And they got on with this, and I was quite excited, and I did a submission about what I thought the law should be, as did lots of others. And it was all progressing well, but in 2019, the government asked the Law Commission to look at the law of marriage and stop work on the wills project. So it really upset me that that's how the government treated private client law. It was less important than the law of marriage, or less urgent. So anyway, they resumed work at the Law Commission in 2022, and they consulted again in October 2023 on just two topics. One was electronic wills, and the other was in relation to whether or not marriage should revoke a will, following the well-known case of Daphne Franks. Now, the Law Commission has concluded its supplementary consultation, and it's now considered all of the submissions that were made. Some of you may have come to a debate. They held a debate in London, and I was involved in chairing a debate with the Law Commission in Manchester. And we did votes, and the profession, it's fair to say, was split as to whether or not marriage should revoke a will and how on earth you should do an electronic will. So I'm highly excited by this, and I'm just flagging it up now that there's been a big battle on the test of testamentary capacity, whether it should be the Banks and Goodfellow test or the Mental Capacity Act test, and again on whether marriage should revoke a will. A dispensing power: can a court recognise a will where the formalities have not been complied with? For example, I've had cases where you've had a will that's only been signed by one witness. Well, is that going to be valid? Can a court recognise it as valid? At the moment, it would be invalid, and that's it. It would fall by the wayside. So the Law Commission's finished its work. It will be presumably drafting legislation, a new Wills Act 2025 perhaps, and it'll be out early in the new year. So I'm really excited about this. I've written in more detail on our website about the Law Commission consultation, so you can read it there. And certainly as soon as, and I mean as soon as it's out, we'll be putting up highlights on our website again. The next bit that I want to talk about is the changes to the non-contentious probate rules, because there's a little bit of a story, and again, I need to do a little bit of an explainer. The work that we do as private client practitioners is governed by the non-contentious probate rules 1987. Now, people don't go to the rules every day because we don't need to look at them. We just know how they operate. But these rules contain various words and phrases which are really quite inscrutable to lay users, such as caveat, a grant ad colligenda bona and bona vacantia, etc. So it's a strange quirk of history that although probate work is chancery work, the rules are actually made by the president of the family division. And this is a bit of a history lesson here, but I find it quite fascinating, again, about delay in probate law. Because in 2009, the president of the family division, Sir Mark Potter, said that the rules, the 1987 rules, were out of date and needed to be reformed. So he got together a working group of clever people to make amendments to the non-contentious probate rules. And their work took 4 years. And then they were produced in 2013. And again, I find this an irony. There was a new president of the family division by then, Sir James Mumby. And as I say, it'd taken 4 years for them to do it. And they go, right, you lot, you members of the profession, you've got 2 months to tell us what you think of these rules. And they did that during the summer holiday, right? So, right, quickly, it's really urgent now. You've got to do it. Let us know what you think within 2 months. And again, loads of people, we made comments and we said what they should be doing. And we submitted them all to the president of the family division. And they then produced the probate rules of 2013. Amazing. The probate rules of 2013. And then what happened? They've written the complete set of rules. Nothing happened. Nothing happened at all. You can find the draft probate rules. They're on the internet. But everybody's ignored them. Anyway, because they've never been introduced, they've never been approved by Parliament. It's a statutory instrument that needs to be approved, and they've just ignored it. Anyway, to cut a long story short, Sir Andrew McFarlane is now the president of the family division, and he wants to look up and to revise the work in dealing with things that still are out of date. And so, to cut a very long story short, they're going to be looking at these rules again. They will be behind the scenes working on the reform of the rules. Now, again, as chair of the Law Society Wills and Equity Committee, if anybody's got any comment about any of the rules, things that drive them mad, then please send us an email and we'll see what we can do to feed it into reform. I know that they'll be looking at caveats, the caveat process. It's likely that they'll be called objections rather than caveats. They'll be renaming a grant ad colligenda bona. They'll probably be calling that a collection grant, and so on and so forth. So things are on the foot behind the scenes. I just hope it doesn't take them 4 years to consult again and then nothing will happen. But it does look as though movement is happening now. So that's going on. Again, we've got details in our portfolio. Next, I just wanted to look a little bit briefly about the case of Waldrop and Searson. It's a 2024 case, and it relates to executor disputes, because on our site, you'll see there's a graph showing the number of cases year on year. I mean, there's a massive increase. Disputes with executors is a massive part of our work now, and sometimes that's because executors fall out between themselves, or sometimes executors fall out with beneficiaries. Now, the case of Waldrop and Searson, as I say, it was a 2024 case, but the facts go back quite a few years. And what I like about this case, it's just a bog standard administration estate. It's not a huge estate. Indeed, the estate was under £300,000. But in 2008, because there's a few lessons to learn here, a lady called Betty Bradshaw died on the 5th of April 2008. And she made a will, leaving a will to be divided between her two adult kids. And if one of them died, then it went to her child. Now, as it happened, in fact, one of her children died before her. So the estate was divided between her grandson, Matthew, that's Matthew Searson, and Jane. And what happened was that Matthew got a grant of probate and he sold an estate property in 2011 for £269,000. But that was it. He did nothing with the money. He sold the property and sort of just kept it, and he ignored correspondence, and Jane was chasing things and trying to make things happen, but he just didn't do anything. So perhaps it's understandable that she was reluctant to get lawyers involved, but she did. And at the end of 2023, she instructed solicitors to make an application to court that Matthew should serve a witness statement and make an interim payment of £100,000 just to be getting on with, and the witness statement to explain what he'd done with the estate and where was the money. But he ignored it, so they had to go back to court again for a penal notice to be put on the order, and they got that put on, and he ignored that, even though it was personally served on him. So then they made an application to commit him to prison for contempt of court, and the matter was heard on the 4th of July 2024. You see, this is bang up to date here. Matthew didn't attend. So what happened? Well, the judge said, yeah, you're in contempt of court, but he adjourned the sentencing until the 6th of August this year. So Matthew didn't attend. So the judge issued what's called a bench warrant for his arrest. And this was amazing because, in fact, Matthew was arrested coming back from holiday on an aeroplane at Stansted Airport. I mean, it must have been great for Jane, but horrific for Matthew for that to have happened. And they brought him to court that day. And that day was the 20th of August. And the matter was brought back, as I say, Matthew was there, and he'd had legal advice, and the judge actually sentenced him to 9 months imprisonment. 9 months imprisonment for failing to hand over the money, but it was going to be suspended on the grounds that he pay an interim payment of £110,000 by the 19th of November and still produce his witness statement. So this case raises lots and lots of issues. We've written about this in our notes, so you can see the further detail about the case. But firstly, it shows and reflects the difficult number of steps that have to be taken to require a defaulting executor to comply with their duties. It's not just one court hearing, but a whole series of court hearings. Secondly, and tragically, it just shows the problem about delay. We always say to people, look, if you've got a difficult decision to make, then make it. Don't delay. Don't just leave it. Don't just leave it on the background because it won't resolve. It's going to take somebody with courage to be able to actually force the issue. So if you've got problems like this, don't delay. If you don't do these sorts of work yourself, then please bring them over to us, because we're always happy to discuss cases and to help people find solutions. So again, the notes are in our page, our web page here. That's it. Thank you very much for listening to us. We'll be back next month. Each of these will be likely to take a different format, and we'll introduce you to different members of the team. Thanks for listening. I hope you found it interesting.